Looking forward to it, sir.
Thank you so much, Justice Mukul Mudgal, for taking out the time and speaking with us on the third Law and Constitution dialogue that we are holding over here. Let's dive straight into it. We're talking about reforms in law, you're talking about arbitration, and you know, there need to be prosecution on a number of issues that you have raised these grievances. So you spoke to me just a moment ago about the abolition of Order 21. And when you talk about, you know, execution that takes longer than the actual lawsuits in the court.
Look, I'm happy that Justice Kaul is here, who's done a lot of original side practice, so he will certainly know what I mean. You see, the battle of a person who succeeds in a suit, who's called a decree holder, starts really when the execution proceedings take place. And execution can take very long because it goes to another judge, not the same judge. If you abolish Order 21 and say that same judge who has passed the judgment shall enforce it not later than 60 days, that will clear a lot of barriers.
Okay. And then talking about these false affidavits and how there needs to be prosecution on these false affidavits. You could give me a detailed account of what are these lacunae that have to be filled?
Look, there are routinely affidavits which are filed, which are false, to the knowledge of the deponent. Of course, sometimes the lawyer is also responsible. If prosecutions are resorted to which are available in law, then it will have a deterrent effect. It will have a deterrent effect, and it will lead to less litigation and faster litigation.
And you've spoken about also, you know, false pleas. You said that courts should award heavy costs for all these false pleas that are piling up in the courts.
Yeah, if false pleas are resorted to, then 1 minute. If false pleas are resorted to, then the court must impose heavy costs, which would be a deterrent. No point saying 500 rupees, 1,000 rupees cost. Some people delay the proceedings, especially the defendants.
I just request you to keep your mic a little closer to your mouth.
Defendants delay the proceedings, and I think if heavy costs are imposed for false or wrong statements, it will lead to an expeditious disposal.
You also want to bring to focus the case of arbitration. You talk about, you know, lawyers have a long time because they're first attending the courts and then they are figuring out the arbitration cases. So you spoke to me and you told me that, you know, the hours should be designated from 11 a.m. or 10:30 a.m. to 4 p.m. for the arbitration cases to be
what
heard.
happens is a lot of delays caused by lawyers who appear in court also appear in arbitration. So there's always a problem. Sometimes they say my case is reaching in Supreme Court or the High Court, and the courts would generally be, the arbitrators would be generally reluctant to dismiss a case on that ground. So it gets adjourned. Secondly, the lawyers who have court cases and arbitration like to come only at 5 o'clock. At that time, most of them are tired, and sooner or later, the arbitral proceedings get adjourned. So if you restrict arbitrations to Monday to Friday and from 10:30 or 11 to 4, you'll see a lot of expeditious disposal.
Right, absolutely. You also spoke about Section 34, challenge to the award. Section 34, challenge 34, challenge to the award.
Yeah.
Could you describe to us what exactly it is in layman's
terms? You see, what
terms?
happens when an award is passed, the remedy for a dissatisfied party is to go and challenge it in a court under Section 34. Barring 4 or 5 high courts which have original jurisdiction, all these awards are challenged in district and sessions court, civil judges court. Now, you see, civil judges, those judges of the district judiciary would be very reluctant to interfere in an award. Supposing I, as a former Chief Justice of Punjab and Haryana, have passed an absurd award, the district and session judge who hears the challenge would be very reluctant to set aside my award, just adjourn it. That's how the matters keep on getting delayed. Okay.
So what could be a measure to not let this happen?
All challenges in all states of India must lie before the High Court, Section 30. That will certainly improve.
Okay, all right. Then again, talking about counterclaims, you say there is no fee involved in an individual or a client counterclaiming to the claim that has already been filed.
Sometimes, or most of the time, what happens is a claim is filed, and the defendant who is defending the claim files a counterclaim. The purpose largely, in many cases, is to delay the proceedings, because counterclaim also takes time. And the party which is stronger financially and economically, doesn't matter to it a delay, but somebody who's claiming amount with a smaller party will certainly be hurt by such a thing. And therefore, if there is a claim and a counterclaim, ask them to pay arbitral fees according to the quantum of the claim or the counterclaim.
Okay. And let's also talk about the Plea Bargaining Act. You've spoken about how it should be modern and practical for all parties to be advantageous, to take advantage of it.
This Plea Bargain Act, I think, was enacted, mostly forgotten. I don't think anybody uses it. You see, I'll give you an instance. There is a fight in the neighborhood. Two groups clash with each other. There are some injuries. Later on, the elders of the area get the matter settled. But there is a precept which says, no, it's an offense against public morality. It cannot be handled. I think it's time we moved on from such dated concepts.
All right.
Have a modern, practical and sensible Plea Bargaining Act.
Talking about plea bargains, and then there are hundreds and thousands of people who have been charged and prosecuted in court. They are languishing in courts. And
before we pass on to that, there's one more thing I'd like to say about arbitration. Is, there is a recent judgment of Kalashnath versus DDA, which says that the damages have to be actually proved. I think this is based on a Maula Baksh, which is the judgment of 60s. And the economic times have changed completely. My view is Kalashnath needs to be revisited, where two corporates have entered into an agreement and have specified the damages in event of a default. I don't think the arbitration should go into that issue. Should award, I think Justice Kaul is sitting here, he would know that proving of damages takes a long, long time, and matters.
Right, okay. And then coming to, use of Probation of Offenders Act.
Yeah, that also is very important. Again, a forgotten act, there are small offenses, people are serving jail time, sometimes more than their maximum period. Therefore, I think it's necessary to have Probation of Offenders Act more rigorously. It exists on statute, but hardly used. And lastly, there are under trials who get bail, but cannot furnish the financial security. There's a judgment of Justice Krishna Iyer, which clearly says that in such a case, personal bond is enough and bail should be granted.
Okay. Now I also want to focus on the other role that you are fulfilling currently, which is the chairperson of the FIFA Governance Committee. If you could shed more light into what all goes into you chairing this committee, and how does the world of sports governance look like?
Chairing the committee is the usual thing. You listen to some 11 people in the governance committee, some very learned, some not so. So you have to listen to everyone, but then you have to take a firm stand. That is how I think works. There are 211 countries governed by FIFA, which I think more than the United Nations has, because of various reasons.
And also you were also appointed as the chairperson of the Ethics and Governance Committee of Coco Ultimate.
But nothing has come to me as yet.
Okay. And I want to overall generally talk about the sports governance evolution in our country.
You see, lots of efforts have been made. The sports code came into being. Then sports law was suggested by a committee headed by me, but it's still in limbo, in the sense that you see, this sports law, sports governance needs certain reforms, such as term limitation, such as, practices of disclosure of, it's called a third-party declaration. That should be there. There are various things like this, too long to go into, which should be there in every sports association. There are, BCCI has its faults, but still the best governed sport body in the country.
Yes, I absolutely was coming to that. BCCI, the most powerful, the richest cricket body across the globe, and which is in India. But barring BCCI, we have not seen any progress, whether it is in the field of football or basketball or tennis. Do you think India has, at this point of time, the potential to have more of such sports bodies that are going to be, then setting an example for the rest?
Look, football in Melbourne Olympics, we finished 4th. We were semi-finalists, lost to Yugoslavia or Czechoslovakia 3-1, which was a great performance. Unlike boxing, where medals are given to both the losing semi-finalists, here it wasn't given. But from there, we have slid down to 134 in the world rankings. Now they're near 100. It's improving, but we need to pay a lot of attention to development of youth, have football academies, because football is the world's most popular sport. And it's the cheapest sport to play. You have the ball and you have some area, you start playing.
Yeah, absolutely. Thank you so much, Justice.
Thank you for the opportunity.
For joining me and telling us all these important things with regards to bringing about reform in our judiciary.
Kind of you to have me.
Thank you.
Thank you so much.